Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Sorry for the background noise. The AC is going full blast. It is actually hot as hell here in Seattle, so we are enjoying something that resembles a summer. Now, as we know, we kind of just wrapped up the United States Supreme Court session, and it was a very interesting session. It was very productive in some ways and not so productive in others. We talked about 4 big cases, but a lot of you who've been kind enough to leave suggestions for video ideas, and by the way, if you have a video idea, you click on that link right there, wanted to talk about this other case that came out that involved the Securities and Exchange Commission, but could have a massive impact on our inalienable Second Amendment rights. Now, I had a chance to geek out on the case, and I was really trying to figure out how could I connect it to the subject matter that we discuss here, and I think I've come up with 2 ways, and I think they're both very productive. So today, let's spend a few minutes, let's get you all educated, let's geek out on a new opinion and talk about the little-known Supreme Court case that may have the biggest impact on your rights. Okay, America, this is what we're talking about today. We're talking about the rulings of the United States Supreme Court in the matter of Securities and Exchange Commission versus Jarkesy. I hope I'm pronouncing that name correctly. This is a challenge to several statutes that lie under the regulatory power of the Securities and Exchange Commission, in particular those where allow SEC agencies to have administrative hearings and then levy very stiff fines against individuals or corporations, all without a jury trial being conducted. Now, I enjoy geeking out about Securities and Exchange Commission stuff about as much as I enjoyed geeking out on the fishing industry in the Loper Bright case. However, I need you to understand the framework here because you're going to see the similarities. To enforce these acts, Congress created the Securities and Exchange Commission. The SEC may bring an enforcement action in one of 2 forums. It can file suit in federal court, or it can adjudicate the matter itself. The forum the SEC selects dictates certain aspects of the litigation. Now, in the past, the SEC had the ability to administratively rule over certain matters, but once we passed the Dodd-Frank Act, well, then suddenly the SEC's ability to go after a lot of corporations and individuals was greatly expanded, and their use of these administrative hearings, of course, greatly expanded as well. But the United States Supreme Court has made the following finding. When the SEC seeks civil penalties against the defendant for securities fraud, the 7th Amendment entitles the defendant to a jury trial. The Supreme Court has also gone on to state, the right to a jury trial is of such importance and occupies so firm a place in our history and jurisprudence that any seeming curtailment of that right has always been and should be scrutinized with the utmost care. And then, the most important rule of law, and we'll explain this in a moment, but the most important rule of law to come from this opinion is, the 7th Amendment guarantees that in suits at common law, the right of trial by jury shall be preserved. The right itself is not limited to the common forms of action recognized when the 7th Amendment was ratified. Now, understand that the Supreme Court has reached this ruling when the only sanctions and/or remedies that were at place was very large civil fines. No one was looking at going to jail. No one was losing any constitutional rights. All that they were going to lose is a significant amount of money. I don't mean to make light of it, but no one was going to jail over any of these violations. But despite all of that, the Supreme Court has ruled, in this case, the remedy is all but dispositive. For respondents' alleged fraud, the SEC seeks civil penalties, a form of monetary relief. Such relief is legal in nature when it is designed to punish or deter the wrongdoer rather than solely to restore the status quo. And listen, what the court is saying here is listen, if we go back and we look in history, and if there was some common law act that could be taken against an individual that is similar to what's happening here, well, then the 7th Amendment guarantees that we have jury trials. As the court put it, if a suit is in the nature of an action at common law, then the matter presumptively concerns private rights, and adjudication by an Article III court is mandatory. Now, the SEC here tried to say, well, listen, there's this public rights exception where if we're talking about large regulatory schemes, oftentimes large regulatory agencies need to actually enforce that. But here's what the court said. The court said, hey, listen, that's fine, but here we're talking about actual actions being taken against real life individuals. So the types of things that we may have some exception under the 7th Amendment would include things such as the collection of revenue, aspects of customs law, immigration law, relations with Indian tribes, the administration of public lands, and the granting of public benefits. Okay, so with that in mind, if we have penalties which existed kind of similarly in common law back in the day, then the 7th Amendment dictates that we are entitled to a jury trial. Where could we see that? Well, there's two areas as it relates to our firearms issues, and this is what I really want you to be aware of here, okay? The first one is a little more innocuous. This is the individual who accidentally takes their firearm through a TSA checkpoint. Now, this happens with far too much frequency, and I'm not going to preach at you about lawful and responsible gun ownership. You all know better. But the only way that you can be charged criminally with trying to take a firearm through a TSA security checkpoint is if you do so willfully. And if you do so willfully and with knowledge, you absolutely positively could be convicted of felonies. 99.9% of the people who do it accidentally, and what they're subject to then is a civil infraction. However, that civil infraction can be as much as $5,000. And for those of you who've ever had to deal with it, either because you accidentally had this happen to you or you're a lawyer that have had to defend people, you will know that the way the TSA says that is the mere strict liability act of trying to take the firearm through security, even though it was done without knowledge, subjects an individual to fines. And what do they typically say? They're like, hey, listen, you could pay X or we could do this administrative hearing, but if you do this administrative hearing, things are going to probably get a lot worse. Now, some people are concerned that if we start jamming up TSA saying, hey, listen, we need to have full-fledged jury trials, which is exactly the position that we should be taking, that will suddenly force the federal government to charge more and more of these people with felons in federal court. Not true, because when we take a look at the applicable statute, which is 49 United States Code Section 46505, we know that you can only be charged criminally for attempting to take a firearm through a TSA secured checkpoint if the evidence shows an individual who willfully and without regard for the safety of human life or with reckless disregard for the safety of human life violates this subsection shall be fined under Title 18 and imprisoned for not more than 20 years or both, and if death results to any person shall be imprisoned for any term of years or for life. So the criminal sanction only occurs if they can prove that you did so willfully or with knowledge. So there really is not a legitimate threat for most individuals who accidentally try to take a firearm through a TSA security checkpoint. So I think that anybody who's representing individuals on these types of causes need to be very, very aware of that there is a legitimate argument that the way TSA is administering these fines is unconstitutional in nature. Now let's get to the more important one, the one that really, truly affects a lot of people, red flag laws. Because if you're telling me that a fine that is about to be levied upon an individual by the Securities and Exchange Commission warrants a jury trial, then how does not the stripping of an individual of an otherwise constitutionally guaranteed and alienable right without a jury trial even come remotely close to comporting with 7th Amendment requirements? And so I believe that if we're going to take a look at the low burden that requires or mandates jury trials, administrative agencies assessing civil financial fines, how then does not the stripping of inalienable rights under the 7th Amendment also dictate that we must have a jury trial? And if that's the case, if that is the case, this case has a huge, huge potential to ultimately and forever alter the manner in which red flag laws are executed nationwide. Okay, the case once again is Securities and Exchange Commission versus Jarkesy. It is a doozy. If you're having a hard time sleeping tonight, don't worry. We'll link it up down there so you can geek out on it for yourself. Maybe you got more questions about this or anything else related to what's left of our Second Amendment rights. If you need to get a hold of Washington Gun Law, all of our contact information is down there in the description box. Maybe you got an idea for a video like this video. A lot of our viewers actually sent in suggestions, said, can you do a video on this? If you got an idea, click on that link right there, because like, as you know, some of the best ideas we ever had were not our ideas to begin with. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.